I am absolutely delighted to be introducing Marc Raspanti from our Pietragallo firm in Pennsylvania. Marc is Philadelphia-based when he's not traveling the world, either sampling whiskey or, more importantly, engaging about his speciality and one of Pietragallo's specialities, which is whistleblowing. He's here today to lift the lid on whistleblowing in the US and how that translates to other parts of the world. I see we have Guillaume Valencia with us from Madrid, as well as an American audience. So without further ado, I'm going to hand over to Marc, because I know you can introduce yourself much better than I can do, since you know me, since you know you better than I do. So Marc, the floor is yours.
All right, good morning and good evening, depending on where I am. Thank you very much, Keith, and thank you for having me. I've designed this as a twofold presentation. One for American audiences who might not be as familiar with all of the whistleblowing options, but I'm also particularly interested in the rest of the world, and I'm spending more time chatting with others in the world, particularly my European counterparts, although I've had discussions with some of the East European, as far as the West European, who are all very interested in what we're doing. If you advance this slide, if you could. Okay. All right, just go back one if you could. All right, so a little bit about us, a little bit about our firm, which is there. For better or worse, I've been in this space for about 35 years. And that corresponds with the resurgence of the modern whistleblower statute, which we'll get to in a second, which was passed in 1986. We've been fortunate enough to have recovered now over $2 billion in recoveries from both federal and state, and we'll get into that. But as we get to the next slide, let me make a couple of observations. So whistleblowing for many in the United States and elsewhere has a generic connotation to it. A whistleblower has become a term of art, at least in America, for a lot of things. We're going to be talking about whistleblowers who take advantage of actual statutes. And in the United States, in watching the genesis of the statute and the way it has progressed, the modern statute, in a second we'll talk a little bit about how it got there, the American public seems to embrace whistleblowers as almost a fourth or fifth rail. And so it used to be that there were tremendous confidences in some of the traditional institutions. I think that waned, and then they moved to the press. In some respects, that has waned. And there seems to be a view, at least in the American audience, and I make this distinction because that's not the way whistleblowers are looked at in Europe, for example, or in other parts of the country, where they're looked at with, I think, some disdain. But in America, whistleblowers have been embraced and have done fairly well, doing fairly good. The modern whistleblower statutes, sometimes referred to in the United States as the Quitom statute, Quitom being a Latin derivative of he who brings it on behalf of the king, literally goes back to the Middle Ages in England. And actually, there were many whistleblower statutes that were in existence at the founding of the United States in the 1700s. And why? Because we didn't have a Department of Justice, we didn't have a police department, we didn't have an FBI or a CIA. And so whistleblowing statutes were designed, if you find fraud and you can bring it to the attention of the sovereign, we'll give you a piece of the action. That's pretty much the way it was. And we had a statute that was passed back during the time of Abraham Lincoln. And that statute stayed in place until the 1940s. And it had some technical issues that courts pretty much gutted that statute. And there was no statute of any value from about 1943 until about 1986. During 1986, we had a tremendous, although compared to where we are now in the United States, buildup of defenses in the Defense Department. The statute was looked at as a way to protect against bloated defense spending, which happens in every country. And as a result of a combination, might have been the last time we've had bipartisan events on anything, we had a Republican and a Democrat who then presented the bill to President Reagan, and it was signed into law in 1986. That statute is a federal statute, and that federal statute is designed to seek out fraud involving virtually any federal program, with some exceptions, and one of those exceptions is fraud involving tax fraud or fraud involving the IRS. And we'll get to some things that have been done later to try and plug that gap. So once the federal statute was passed and it started to have some success, the states decided to start passing their own statutes. And some states have stronger statutes than others. I've spent some time, I see a friend of mine from Minnesota, you have a statute. I actually wrote an article about it, Minnesota Light, because at least the last time I looked at it, it wasn't the strongest statute in the world, but maybe that's been changed. Other statutes like New York is not only stronger in some respects than the federal statute, but it's one of a couple of statutes that has an anti-tax fraud provision in it. So it's unlike the federal statute, the current false claims federal statute. New York decided that they were going to beef up their statute, and there have been some significant recoveries in New York under their provisions, particularly having to do with tax fraud. We could go to the next slide. So the Federal False Claims Act is by far the most powerful statute of its kind. And I'm going to say it as boldly as I can. There's no statute that exists like this anywhere in the world. And I have had extensive conversations with a number of my European colleagues who are trying desperately to pass statutes, and they send the statutes to me so that I can take a look at them. And frankly, they're watered down, they're not that strong, and they don't have some of the key provisions which we're about to get to that make the Federal False Claims Act unique. Now, I'm going to mention one more time that there are about 30 states that have statutes. Some of them are modeled almost exactly like the federal statute. Others are not, but they're designed to go after state fraud. So if you're a resident of Maryland and there is corruption in the building of roads or waterways or bridges or healthcare having to do with Medicaid. Now, much of the statute has migrated over the years from defense contracting, which is where many people thought the statute was designed to be. It wasn't designed to be just a statute to ferret out government contracting fraud, but it's migrated since the 1990s into a statute that almost, I would say the majority of the recoveries are now coming from the healthcare area. Unlike many European countries, we don't have a monolithic system of healthcare. We have a system that has Medicare and Medicaid and government plans and state plans. And so one of the most effective statutes that the federal government has used and we'll get to the next slide in a moment if we can advance it, Michaela, will be how that statute is utilized. It's still used for other kinds of fraud, but the numbers and the recoveries in the last few years have been against the healthcare area. Okay, so let's go through a few mechanics. It's not designed today to get into all the nitty-gritty, which could take a lot of time, but let me give you some of the takeaways that come from this statute. So on the screen is the, or for the American audience and for any other ones, that's the 31 U.S.C. 3729. The statute is divided into two basic areas. The first area is a section and provisions that protect, that in which a whistleblower, generically we'll use that term, under the statute they refer to that individual as a relator, and he relates information to the government. And so the whistleblower, to the extent that they file under the statute, shares the cause of action with either the United States government or a state government if we're going under one of the state statutes, and sometimes both. The second provision, which is quite unique in federal law, and we'll get to that in a second too, are anti-retaliation provisions that protect the whistleblower from coming forward and being retaliated against. And some of the statutes that are attempted to be passed right now in other European countries, I've had discussions with the Italians and the French and even the Germans in trying to pass protections for whistleblowers, although they have not gone as far as the United States in offering rewards, which we'll talk about in a second. So if you look at the basics of the statute, the relator or the whistleblower will bring the claim, and I'm going to deal with the federal statute now just to save time, brings it on behalf of the United States, okay? And so if that whistleblower is successful, he or she will get a portion of the recovery that comes back to the American Treasury. And that recovery can be anywhere from 15 to 30%. The statute covers all fraud schemes with the exception of the Internal Revenue Code. So whether it's fraud against the military, COVID-based fraud, fraud against the healthcare system, every imaginable type of fraud, and some that we haven't yet imagined, has been brought under the statute. The IRS now has its own whistleblower program, and we'll talk about that in a second. And something that's pretty unique to American jurisprudence, which prides itself on transparency. This is one of the few statutes and few provisions, frankly, other than federal grand jury work, and I'm a former prosecutor myself, that when you file a complaint, a whistleblower complaint, you find an appropriate federal court, there's 93 of them, in the United States that's somehow connected to the fraud, and that connection can be rather loose, frankly. And that particular complaint, unlike most other things in the United States, is filed ex parte, meaning the defendant and their counsel don't know about it, and it's filed under seal. And so when you file one of these cases, they're sealed by a federal court. The parties are completely under the provisions of the seal. And in fact, if you violate the seal, you may, as a remedy, have that case dismissed. So it's rather unusual. The other unusual part about the Federal False Claims Act case is that by design, if the federal government decides for whatever reason they don't want to pursue your case, you are statutorily allowed to pursue the case, and If you succeed, you get a higher recovery, 30%. In another area that does not exist in many statutes, there are some statutes, but if that law firm takes that relator and litigates that case, and we've done these probably more than 10 times now, you are entitled to receive all your costs and all your attorney's fees for the efforts of recovering money to the United States. So that's pretty unique. That doesn't happen in many statutes, and I doubt it happens in at least the statutes that I've seen in Europe. Could you move to the next slide, please? Now, something that I think a lot of people just don't realize, and even my colleagues who have worked in this area, virtually anyone can be a whistleblower if they can provide direct and independent information, meaning that they have the goods on fraud. They know what is going on. They didn't read about it in the paper. They didn't poke through somebody's garbage and find out about it. They actually know something about it. But there is no requirement that the relator be a United States citizen or even a corporate insider. And so the interconnectedness of the world and of, frankly, American companies that are all over the world make it an interesting situation. I was just in Scotland for a few weeks, and I was walking around Scotland, and I started to see a lot of American companies that were in Scotland. And, you know, being an inquisitive fellow, I did a little bit of research to see how many American companies had significant offices or presences just in Edinburgh. I didn't even go beyond Edinburgh. I counted 39 major corporations that had American citizens there, that had expatriates, that were all names that you've heard of. And so, you know, it's quite interesting. There are some provisions and there are a lot of specifics. You don't get the opportunity to have a pretty nice reward without some mechanical issues that the statute has. You need to be first. There's a bit of a rush to the courthouse. So if you bring 3 allegations, a fraud against a company or an individual or a corporation or an entity, and somebody else brings 4 of them, but you beat the person who brought 4, you might be able to recover on 3, and the second person might be able to recover on just 1. I know that's a very simplified way of explaining about 25 years of jurisprudence, but there is a first to file bar that's built into the False Claims Act. Now, I told you it's pretty unique and it's pretty strong. In addition, and let's simplify it. So I submit a claim, a false or fraudulent claim, to the United States for payment. And I can prove that that claim was false. And it was submitted to the United States or one of its agencies, and they paid that claim. Not only can I get treble damages, as it's indicated in this slide. So if it's $100, it's now $300. But the penalties for each claim range now from $13,508 to $27,018. Now, you're saying, where the hell did these things come from? Where did we get these odd numbers? Well, believe it or not, every couple of years, the United States Congress increases the penalties based on inflation. So think about it. If you're a healthcare company and you are 24 hours a day submitting relatively small claims to the Medicare system or to any other government system, even if it's $50 a claim, if you're doing that 24 hours a day, 7 days a week, 365 days a year, you can take a relatively small claim and turn it into a giant claim. And that's why this statute is trending upward beyond $75 billion. They also have some pretty extensive retaliation provisions that don't exist in any other statute that I'm aware of anywhere in the world. And so if you are retaliated for the act of whistleblowing, let's assume you brought the case and the case failed, but you had a good faith basis to bring the case, and you were engaged in protected activity. And the statute defines protected activity as trying to stop a false or fraudulent activity. Even if you were wrong, you had a subjective belief that it was false, but you tried to do it, you can get very powerful recoveries from that, including attorney's fees, double back pay, and any type of special damages that are going to make you whole. That doesn't exist in many statutes. And that was added in 1986 by the Congress because under the old statute, there was no protection. And whistleblowers were complaining that they would come forward and then they would be retaliated against. And in fact, that statute has been expanded. You can advance the slide. And I've had the opportunity to review and give input on some of the European statutes through some of my colleagues, which frankly I enjoy quite a lot. But they don't have the same view when it comes to protection of the whistleblower. I think a lot of times some of my European colleagues believe that the whistleblowers are kind of like rats, and if they should not come forward or they make a mistake, they should be prosecuted. And I've tried to explain that there's a balance between trying to do that. I'm not sure I'm there yet, but it's interesting. Some of the Scandinavian countries have come a little bit farther in that area. But I do think that there has been a real study of some of the American whistleblower statutes to see where the rest of the world might be able to take things that could be of value to them. All right, let's just give a little bit of the process of filing a False Claim Act whistleblower process. Again, this is under the False Claims Statute. And this
Marc,
is, yes.
Marc, just before you move on to that,
Sure.
Why do you think there is that difference between the US and the European view in your experience? I mean, you touched on the sense of there seems to be this feeling in Europe that if you're a whistleblower, you are, you're ratting out your employer, and presumably that's anti-competitive, anti-commercial. But is it more than that?
Well, it's a good question, and I've had the opportunity to sit down with, I would say over the last few years, maybe about 9 or 10 attorneys who I have a lot of respect for in different countries, some in Zoom and some in person. Once in a while, Bill lets me travel outside the United States and I get a chance to meet some people. And I had long discussions, sometimes with a little bit of wine, sometimes without. And almost universally, they had a knee-jerk reaction. And so I was sitting with, some wonderful people from Italy, and I happen to be Italian, and I asked them, well, what's the problem? We don't like rats. Okay, so that's what they said in a funny way. The Germans really didn't like many of the statutes, but they saw that it was a very good thing. Curiously, some of the former Soviet republics, I've had discussions with the Estonians who like the statute. Some of the people in the Scandinavian countries like the statute. And so I think it is some historical biases. I think they don't want to incentivize a group of people who they feel maybe can't be controlled. And they're worried about that. However, they're starting to see where the Europeans are and have passed very, very strong anti-bribery statutes, some of them even stronger than ours, but they're mostly criminal statutes. You know, what we've been talking about, for the benefit, and I should have said, this is a civil statute. This isn't a criminal statute. And so my European counterparts are very comfortable with a criminal statute, but it seems to be, and I only have this on anecdotal, I have done some forums, I have read some things, I'm actually starting to have more and more dialogue, and a fascinating discussion with a Romanian lawyer who is a very excellent white-collar lawyer there. So I think everybody is examining it because they're trying to ferret out corruption. That part, they agree with us. They don't like corruption. They see how corrosive it is for their countries, but they haven't gone as far as we have to come up with, let's call it an alternative force, which, let's face it, are private. This is a private partnership. I mean, many, many times it's the whistleblower that's driving the train. And so, you know, we sometimes refer to that in the United States as private attorney generals. So it's a fascinating but evolving area, Keith. And I love to get on a chat with it, because I love to hear the other point of view, and sometimes it's excellent.
Well, I cut you off in mid-flow, so I'll let you get
That's
back
all
to
right.
that.
No,
But we have Guillem from Madrid
okay.
on the Zoom, so maybe at the end
Sure.
we'll come back and see if Guillem can add any insight or a perspective on that from the Spanish
there's a lot of there are a lot of bills that are floating around, and I'm going to refer to it collectively as the
conference right now.
Some of the congresses of various places, the parliaments. There's a lot of bills, and I get the bills, but they don't seem to make it to, and I'm just collectively, because each government has its own way of doing things. But I do think there's going to be progress, because the rest of the world looks at, 75, 80 billion dollars of recoveries, and they see what whistleblowers have done, and they keep passing tremendous bribery and banking statutes and other things that are protecting all of Europe and the world. But, I think they have to get to a point to embrace something that happens to work in America. Not that everything works in America, but this particular statute seems to work. What's up here is a very simplified 4-step process of how the False Claims Act works. A relator or a whistleblower, through his counsel, determines where in the United States that filing should happen. And frankly, where in the United States that filing should happen is an art form, as some of my colleagues would know, because even though we have a unified Department of Justice, I can't say that every office in the United States has the same expertise for handling these cases. A federal investigation by statute then commences, and the various law enforcement that is associated with the particular fraud will be engaged. So there'll usually be an American prosecutor. And so if there's fraud against the Medicare system, there might be a Medicare inspector general. If there's fraud against the postal system, there might be a postal inspector, et cetera, et cetera. Department of Defense has its own investigators. And so that's how it proceeds. The matter stays under seal while it goes forward. And then if they're successful, if we get to an end, whether it be by settlement or by litigation, those successful whistleblowers entitled to 15 to 30% of any recovery that the United States might get, in addition to their legal fees and all the costs of the litigation. So that's a nutshell of a very complicated statute. And this, what I would call the statutory protections that come under the False Claims Act. All right. There are, and I want to now move to what I'm going to refer to as the reward programs, also very unique in American jurisprudence. If we can go to the next slide. And so I've just told you the statutory meaning that I can go to a law book in the United States, I can open the book and I can see protections that the whistleblower has as an actual litigant. he or she can go into court, can stand up before a judge and can say, yes, I agree with this. No, I don't agree with this. I want to move forward. He or she has rights that exist under the federal program. We're now going to talk about the other whistleblower programs. If you can advance the slide, Michaela. And these are what I refer to as reward programs. So what happened is, after the Federal False Claims Act statute was amended in 1986, lo and behold, the first recoveries started to hit about 1991, 1992, 1993. And while some of them were small, some of them were huge for American fraud fighting background. I mean, I remember when the first major settlement came out of about $111 million, that was a significant settlement, small by today's standards in America, but large. And so the rest of the United States government, particularly certain highly invested agencies, through some urging of some senators, started to look at reward programs. And I mentioned to you that the Federal False Claims Act does not have any way to get at IRS violations. And so the Internal Revenue Service, which is the monolithic protector in the United States of anything having to do with federal tax violations, both criminal and civil, now have and have had for some while a reward program. And when it's a reward program, basically, you don't have to necessarily litigate a case. And that's pretty much the way for the rest that we'll describe. You submit a number of forms. On many of the programs, they're anonymous. You have no input in the process. Sometimes you don't even know what the process is. And if you've made out your case and you've gotten the attention of one of these agencies, you can and will get a reward from that agency for bringing that to the attention. Again, underscore for anyone who's not an American on the call, you don't have to be an American citizen to do it. I've represented both on the False Claims Act case and on these cases, non-American citizens who have been brought to me by lawyers from all over the world who see that there's something going on as a result of some involvement or connection to the United States. And as I mentioned to you, I just used Scotland as an example, and I'm just using Scotland as an example. There are many companies that are connected to the United States that do it. The Securities and Exchange Commission, which is a very powerful agency in the United States, they have not only have they added a reward program, but at the moment, I think they're running that program better than virtually any other reward program. I think that the people at the SEC are getting an unprecedented amount of tips, as they refer to them, from whistleblowers, and are rewarding in record amounts, some of which are going to non-Americans, violations of the SEC. The corollary or close to the SEC is the Commodities Future Trading Commission, CFTC. They've added this particular program of late, and they're starting to turbocharge this program. The Department of Treasury has also added violations of the Bank Secrecy Act, and that particular section of the IRS, which deals also with the Department of Justice, also has a lot of robust involvement with the rest of law enforcement all over the world. So I predict that this is where many of, for example, my European counterparts, where I have more familiarity, will start to see more involvement in that area. We could go to the next slide. So each of these programs, for simplicity's sake, follows the same general process, very different from the False Claims Act that is statutorily prescribed. I go to the book tells me exactly what I must do. It tells me exactly what powers I have, and I'm a full-blown litigant. I can go into court, and I've been in court, and I can actually try that case on behalf of the United States, even if the United States is not in court with me. If they have delegated that power to me, and I can represent both the United States and or a state. In this case, these are reward programs. And a lot of times they refer to them as reward programs and tips, all right? Now, tips is a subjective term. And in order to get the attention of one of these agencies, and these are complex cases, you have to put together a very robust complaint. But unlike the False Claims Act, once that is done, it's really up to dependent upon the agency. Now, the good and the bad, there's good and bad in everything. The good thing is you don't have to do much more than be available to respond to the agency. The bad thing is you really don't have any idea what the agency is doing. They're a black box, and that has concerned some people in the whistleblower bar. They have made some attempts for transparency, but in this particular area, unlike the False Claims Act, anonymity is still in place. So there are whistleblowers who have gotten $10, $20 million, $5 million, and no one knows who they are. And the only requirement is they have to pay taxes on it if they're an American citizen. But that is unique in American jurisprudence. So the process for each of the programs, and there are other programs, frankly, we don't have the time to talk about them, but frankly, they're not as strong. These are the ones that if you read the Wall Street Journal, and it's funny, if you read the Wall Street Journal, the New York Times, you'll often see a story and you'll have to get to the bottom of the story to figure out that that person was a whistleblower or that person, because they often don't like to highlight that, but that's how you'll get to it. So under these programs, you're in a minimal award, again, 10 or 15%. Sometimes it's a lesser reward. Sometimes it's higher. It's completely dependent, though, on the agency. Under the federal program, if I don't feel that I am happy with the reward, I can go and litigate that against the United States, and I've done that. Or I can go to a federal district court judge appointed for life and say, I feel that I should get more money, and I've done that. I can't do that under the TIP programs, all right? And these laws do have, almost anyone can serve as a whistleblower as long as they have valuable information. And I predict, but I can't prove it because I don't have the statistics because they're anonymous, with the exception of what leaks in the press. These programs are being utilized more and more by non-resident Americans, all right? And I had an interesting False Claims Act case a number of years ago where I had an American, actually he was not an American, he lived in America for a short period of time. He then went to Germany, ended up in the Philippines, and he had been working for a contractor during the Afghanistan war area, and it brought very, very valuable information to the United States. And frankly, it's very difficult in a war zone. And we were in that war at the time he came forward. And we had to fly him in from the Philippines on a regular basis to meet with American prosecutors. That case ended up going both criminal and civil. And when he recovered about $14 million, he went back to the Philippines. I'm still in touch, and apparently $14 million in the Philippines goes a very long way. And so he sends pictures of the various houses and people. So, but it took him, it took courage to do that. And it took, he was convinced it was going wrong. He was also convinced because of some of the contractors in a war zone would disappear. And even though the American authorities were doing the best they could, they're here today, they're gone tomorrow. So those are some of the areas. if we could just move to the next slide. And that individual is Michael Epps. And I was actually wrong. He got 16 million. And so Michael Epps, who I spent a lot of time with, and it was interesting because when we first brought him down to the United States to prosecutors, I didn't know whether or not they were going to believe him, because the tale that he told was pretty amazing. I'll just give you an idea. You know, this contractor was selling water to our American troops, and instead of $1.19, the water was $30 a bottle for a bottle of the water that I have right here, and so on and so forth. All right, but he came through. The international reach of all these statutes are continuing. Frankly, I find it to be interesting when I get calls from European counterparts. Most of the time, the lawyers just want a little bit more. They always find it hard to believe. And maybe this comes from a bit more of the protectionist views of some of my colleagues, that they can't believe that you don't have to be an American to actually use the statute. So I have found that very interesting. We can go to the next slide. Two of the three largest whistleblower awards in history involve foreign defendants and misconduct occurring abroad. Now, when I say foreign defendants, there has to be, and there has been, connections with the United States. So if you're a publicly traded company under one of the reward programs, and you're cooking your books, or you're mischaracterizing this, that, or whatever, it could be an SEC violation, it could be an IRS violation. It could be that you're selling munitions to the United States, and you happen to be a contractor from abroad, and you know the global reach of the world increases, it doesn't decrease. So that's pretty interesting. Just a few examples here. Ericsson, in 2019, I placed a reward there. The SEC awarded a whistleblower $279 million. That's a big number, no matter where you are in the country, in the world. Deutsche Bank, which has had more than enough of its troubles, if you follow the Wall Street Journal, for example, and continues to have trouble, you know, has awarded to the whistleblower under another of the earlier CFTC award programs. And these are sophisticated companies that do trade, that do business on a world scale. And I think that these statutes have opened it up so that they're able to do that and to see that there is opportunities. Now, I've had a lot of discussions with my German counterparts who really heretofore, I'm talking to lawyers, I'm not representing the entire country, have really not liked the statutes. And they sometimes refer to, you know, some of the awards, and they feel that, again, they're incentivizing sometimes bad people. They'll say bad people to come forward. Now, most of our statutes have a governor in them. And so when Lincoln passed the statute, he said, to catch a rogue, you need a rogue. I don't go to find, you know, church ladies to find fraud. I'm looking for people that are close to the fraud. However, if you're so far over the line, most of the statute, and certainly the False Claims Act statute, puts you into harm's way if you have actually gone too far. So that's kind of how we've tried to reach that balance. Next slide, if I could. This just gives you a little graphic of how some of these programs from some of the four major programs are working. For those of us in the business, I think I would speak for many people that the IRS program, despite the fact that it should be one of the most robust programs, I've always thought was a disappointing program. They've had some success, but they really have not, in my humble judgment, embraced it. The SEC, under multiple presidents, Because sometimes you think, well, maybe under this president, it won't go well. And the SEC under multiple presidents has continued to see this as a very important statute. And they've actually had to beef up their office, their whistleblower office, because they are getting an unprecedented amount of tips. And most of these reward programs are required on a regular basis, 1 year, 2 year, to report to the United States Congress what they're doing, how they're improving these programs, and how they're recovering. So sometimes the Congress acts, sometimes it doesn't. The IRS in the past has complained that they don't have enough people to do X, Y, and Z. For those of us who do this kind of work, we've always felt that this will make X, Y, and Z a lot easier for you, but I have not found them. And that could be the mentality of the IRS. And I'm not saying it's a good mentality or bad mentality. It's just that they have not done as well in those programs. Some of the newer agencies, and I think there are more agencies that are looking at whistleblower programs, and they're going to their colleagues. And some of these agencies, like the Securities and Exchange Commission, has a rather robust office and has started to, what I would call, market their efforts. You'll see the director of whistleblowing routinely going to conferences and explaining how their program works. And you don't do that if you're a government bureaucrat. I don't mean that in a bad way, but you don't do that unless you're looking to increase the amount of people that come forward. So those are the trends. I don't see the trends. The trends may fluctuate between the various programs, and we, during this brief hour, have really had a holistic approach at some of what I would call the larger or more prominent American whistleblower programs. So if you put them in their whole, you can see that whistleblowing is here to stay in one form or another in the United States. If you break them out into component parts, which those of us who do, we do that, you will see that one program will go up, one program will go down. And when one of the programs might be wounded in court or through judicial precedent that might change things, more often than not always, under the statutory programs, the American Congress comes in sometimes to patch it up. What do I mean? A court doesn't like something, strikes down a provision. 2 years later, that provision is fixed by the Congress, because the Congress and the Department of Justice and many law enforcement agencies see that the program has worked. I don't know how quickly the rest of the world will get there. I personally find it fascinating because I had the opportunity to look at a bill about 3 months ago from a colleague and asked me to take a look at it. And I spent a lot of time. First, I had to translate the bill the best I could. And fortunately, in downtown Philadelphia, I have access to a lot of great colleges and universities. And once I thought I had a handle on it, I then had a robust discussion. And they were very proud of the bill. And I thought it was like a bill that was somewhere in the 1880s in the United States. But they were very proud of what they had done. And I tried to explain to them how the bill, the way it's written, wouldn't get them where they wanted to be, but they kept telling me that, this is where they wanted to be. So I said, my phone is always here, and I have no problem discussing with it. You go to the last slide. So just to kind of summarize, obviously if there's any questions. So I think the American model, and I'm going to refer to it as the American model because it is a different model. And I guess I in some respects, because whistleblowing statutes, as we mentioned, go back to the Middle Ages in England, I just assumed when I first started practicing that, gee, if we had these statutes, everybody had them. But it is an American model. I think it's a proven model. I don't think people who even maybe don't like it would tell you off the record, maybe over a beer, that it isn't working. The United States Treasury keeps count of the kind of money that comes in. I always get asked the question, and I'm going to answer it now. For American citizens, I can't speak to it. Whatever dollars come in are taxed. So if a whistleblower gets $10 million, he or she's got to pay taxes on it. So the United States actually gets to benefit either way. A little interesting quirk that I learned years ago is that a whistleblower who recovers for the United States and meets all the requirements of a whistleblower actually has priority under American law over the IRS. So at one point in time, I was fighting over the IRS for a whistleblower who owed the IRS some money. We went into a court of law, found a provision I didn't even know existed, which actually provided a quirky little protection for that. So I think the robust anti-retaliation provisions must be part of any statute that's passed. So whenever an American statute is passed, if you don't have anti-retaliation provisions, nobody's going to come forward. And I have had a lot of discussions with my European counterparts and my East European counterparts and some Japanese counterparts, trying to explain to them how important that is. The awards continue to grow, and the rewards continue to get attention. It's not easy at times. I mean, people think they only read about the good things. They don't read about the bad things. The average whistleblower award under the federal whistleblower statute, if you look at all the cases that go and all the cases that don't go anywhere, are a little over $1 million. That's not insignificant. But you know, I have some of my German friends who refer to some of the large awards as the Hollywood rewards, because they think that's Hollywood. So we do get the Hollywood rewards. In my firm, I'm looking for Hollywood rewards, not the smaller ones. But they do work. And I think that I think it's a growth area, and it's a growth area in two areas. One, I think that the states are continuing to pass statutes, although I can't say that the states have had the same success as the federal government. There's a lot of reasons for that we can't get into today. I think the federal government continues to look at it. It's its primary fraud fighting statute. There is no other statute that the United States government has that's recovered the kinds of billions. I don't know, every day you have to check because it's like, but I think it's $76 billion. The United States reports every year, every settlement. So that part is transparent against every corporation, including a number of corporations that are frequent flyers. And that is the end of my prepared remarks. If anyone has any questions, I'm here to answer them.
Who is that gorgeous man in this last slide that we're looking at? Marc, thank you so much. I expected as much, but you did not disappoint. I know we were skimming, but even then with the depth and breadth of what you covered. So thank you. I see we have Sev from Nevada with us. Sev is also Mackrell International Chair, so it's good to have him here. Sev, I'm sorry, I'm going to get this completely wrong, but when we were discussing the one of the topics for the America's Business meeting coming up, funnily enough, in Nevada, you suggested putting something on the agenda about fraud and malpractice. Did that overlap with anything of Marc talking about, or have I just gone off on one as a non-lawyer?
You might be off just a little bit, Keith, but not being in this field at all, I found Marc's presentation this morning absolutely fascinating. So, you know, Marc, I don't know if Bill will let you travel to Las Vegas, but if he does, I think the larger group would love to hear from you. And I apologize, I'm not on video. I'm driving, so I'm
that's
trying
fine.
not to multitask.
Yes, no, Jeremy, my partner, and I are going to be in Las Vegas. And by the way, Nevada, I learned how to say it correctly. Nevada has a False Claims Act and has had one for years. And from time to time, frankly, they've been pretty active. It's an interesting statute. And I had some very good experiences with the first director of the program there. But I really enjoyed working in Nevada and had some experience there. I see a friend from Madrid and would love to know, just in 2 seconds, your view on whistleblowing. I always love to hear, of course, Madrid is a wonderful place, but I'd love to hear the view from Madrid on whistleblowing and what I've talked about.
From a European perspective, or at least from a Spanish perspective, it's fascinating to hear about the component of the financial remuneration for whistleblowing. We have had several new legislations in Spain because of the European directive on whistleblowing channels, not so for the state, but for companies. And it was never discussed. And if it was quickly dismissed as a bad idea. But it's my intuition says that it's clearly one of the drivers behind the huge numbers and and all these amazing things that you were explaining. In Europe, the feeling we have is that the focus is never in the state. It's always in companies and the private sector. In fact, now in most of Europe, companies are obliged to have some kind of whistleblowing internal channels. There are many states without that, and at least in Spain, there is no national network for that. There are some regions, Catalonia, Andalusia in the south, that have some regional channels to that, but it's another world.
Yes. Well, I mean, I wanted to see you added more anecdotal support, but I do like to hear it, and if I live long enough, I think maybe the Europeans will see, because they are passing, as you just mentioned, very, very significant criminal statutes. But they worry that they can't control the whistleblowers. I'm not sure what they worry about, but they do worry about it. And it,
I think it's mainly cultural. In Spain, we have had many multinational companies that already had, for example, for the private sector perspective, many whistleblowing internal confidential channels. And 99% of that were just petty discussions between employees. So there was, so as far as I know, there is no major scandal in Spain that has come through these already established whistleblowing channels or status, as you would say in the United States. So it's a different universe, not even a world, a different universe.
It is. Well, thank you for attending. I enjoyed that.
I think I mentioned to you, Marc, as well, that our firm in the Czech Republic, MK Nosko, which is very digitally driven and tech driven, have just released a platform to allow whistleblower, a sort of template, which they're happy to roll out amongst the European, Mackrell international European firms to help whistleblowers collate sort of standard information to help both the whistleblowers and firms representing them, because there is no such clarity across the European states, and it's managed so differently. So very interested to see how that develops.
I wanted to underscore, Kate, so one of the things I've really been fascinated, and we were talking about this, is some of the former Russian country, or the Soviet countries, that my American view when I would interact with them was, I'm never going to be able to, but some of these countries really have embraced it before the Europeans. I mentioned I've had a lot of dealing in Romania, Estonia, Poland, and they are like, we don't want to be seen like the old Soviet Union. They want to send to the world a message that we're not like that. And I've been fascinated by that, because I like to learn every day. I want to learn. And I love talking to lawyers because no matter where they are in the country, in the world, they've been trained the same way. That's what I find fascinating about this group. You know, their language might, their culture is different, but we all had the same way in which we process information, good or bad as that might be. All right. And so I love to sit down and talk about it. So thank you for the comments from Madrid.
I think you're going to enjoy your interactions with the Mackrell International Group in Las Vegas. Obviously, it's very US centric, but we have LATAMs coming in. We have Harold from Kojima in Japan. I think John is coming in from Dublin. So even our America's business meeting, yes, US centric, but actually is quite an international group. So you'll be able to continue those human and legal conversations.
Well, it's funny, when I walked around Dublin, and maybe I have a jaundiced view of the world. So I'm walking around Dublin a few years ago, my first time, wonderful place. Boy, is there a lot of American companies here, right? And I was thinking to myself, well, yeah, I kind of knew there were some tax benefits, but I stumbled onto like parks and parks of major pharmaceutical companies. And so, my mind wandered. But it is an interesting area. And I think I will be interesting as the American whistleblower programs gray, if you will. We're heading on 40 years on some of them. It'll be interesting to see how they influence, if any. I know my friend from Minnesota spent some time in France, and I've spent some time with the French authorities, and they are doing some interesting things. They're not there yet, but they're working very hard at anti-corruption statutes. So we'll wait to see what happens. It's interesting.
Jerry, I'm conscious that we haven't heard from you. I know Marc's could have covered all the ground, but is there anything you wish to chip in and share with the group?
Marc has covered a lot of ground, and I followed his work over the years. And I know he and his colleague Pam Breck have written a couple of papers comparing the SEA to Italian and French efforts in the whistleblowing space. Question I want to toss out to Marc, if I could. You've emphasized the strength of the anti-retaliation provision in the False Claims Act, and you've also emphasized that individuals from around the world can avail themselves of the American courts and file a case. If you have a person, say, in a war zone in Iraq, and they're working for a foreign company that's providing military support. The company has a contract with the Army. This person blows the whistle. They file a complaint in U.S. court, but the foreign company, at some point, maybe because they were complaining about what was happening, gets fired. Does the anti-retaliation provision protect that foreigner, or is there an extraterritoriality problem in trying to extend that protection to a foreign citizen?
That's an excellent question. I've never seen it litigated, and my view is that it wouldn't protect that person in a foreign country. So that person, to the extent he or she was an American citizen or spent time here, I have never seen it personally under the federal programs. It's possible that under the SEC programs, you could take advantage of foreign jurisdictions, although I have not seen a template for that. And if you try to interact with those countries who have filed, who have retaliation provisions in advising a whistleblower, and many times, and Jerry, you're in the same position, before they take the risk, and I spend as much time telling people not to come forward because it's not for the foolhardy.
Mm-hmm.
And
Definitely.
the whistleblower that I represented, Michael Epps, I mean, he was tenacious and he was strong. And every time I would tell him, you could I don't care. This was wrong. I was there, and I'm not an American, but to see an American soldier risking his life and then spending $30 sometimes out of his own pay, or when they would go to the mess tent to get a beer, the beer was, $29 for a Bud Light, which no one should drink. So, those are some of the things that bothered him. But it is not, and I do not think we have, and I think you would have to put together perhaps, and it's fascinating, and I'd love to explore that, Hague Convention and some other areas. I mean, I get a lot of calls over the years from Swiss lawyers. And I always enjoy, you get the middle of the night, the Swiss lawyer calls, and a lot of times that, they're just trying to get information. And I've spent time in Switzerland too. They tend to be cautious people, as we all should be, and they haven't come forward. But they do methodically want to know because of Switzerland's key and involvement in so many different things, and the interaction with the Swiss laws and the banking laws that people on this call know better than I do, where the Europeans have really strengthened that. So to answer your question, it would be a little bit tricky, and I don't think I could tell a person you're going to be protected. I mean, the protections in the United States are good, but it still requires you to litigate that, as you know, Jerry. I mean, it's got strong protections, but I've got to get a court that's going to protect me. And so far, I've been fortunate. Nothing has happened to any clients of mine. But, I do take that burden seriously when advising a client.
I had occasion to research that a couple of years ago. Got a call from someone in India working for a foreign company, and found just a couple of cases on it, and it supported your initial reaction that there would not be the extraterritorial reach of the anti-retaliation protection, but it doesn't seem to have been widely.
Yeah, I agree with you. The other thing that's interesting in watching the attempt to pass some of the statutes in different parts of the country, and thank you, Jerry, I have written a number of fairly detailed on international statutes. I did one on French statutes. I did one on Italian statutes. I did some surveys on how other ones look at that are. You can go to my website. You can look at those. But some of the European privacy laws, in some respects, are stronger than our privacy laws. And I know you spend some time in France. I think the French have very strong privacy laws, and sometimes the privacy laws interact or get in the way of the whistleblower statutes, and they're still kind of working their way through. At first blush, I would have thought, and I would have thought probably improperly, that the American privacy laws would have been stronger. But I've been very impressed when I've had some cases in France with Franco-American companies that had an opportunity to work through discovery and document processes and what has to be redacted and who can't be, and the rights that individuals have in these corporations, et cetera, et cetera. And I think in some respects, I'm not casting aspersions, but I think maybe superior to what I think we enjoy in the United States. So that's gotten in the way. I have not seen a single robust reward program that has been. I've seen attempts. That's not to say they don't exist somewhere. And I've tried to monitor on a fairly regular basis whistleblowing statutes, not all over the world, but on some of the countries that I'm following. I have seen increasing attempts to protect the identity of a whistleblower and also to protect that whistleblower. But I have not seen the protections that I would want to see before somebody came forward. They're riddled with holes, and I'm the typical statute I've seen outside the United States is if a whistleblower does X, Y, or Z wrong, somehow they're going to get prosecuted. And I keep trying to explain, like, why am I going to come forward? I'm not going to get any money. I might get prosecuted in the process. Well, we don't want to give, we don't feel it's right to give any money. They should just come forward. Okay, maybe you have a different country than I have, but before you take that kind of risk, And I've had that debate, and the debate always kind of ends up at the same spot. But, you know, maybe, Jerry, you've seen some other things that I haven't, or other people on here. But I do think we'll get to a point, you know, in a few years, and I haven't done the math, maybe Jeremy has, but if you took the federal statute, the FCA statute, all the reward programs that have been reported and combine them in an aggregate, and I'm talking about all of them, we have a pretty big number that no one could say is insignificant. No one. And that could be from the United States point of view or from any country anywhere in the world. It's interesting, you mentioned, I think someone's mentioned, I mentioned that the Japanese are really starting to look at some programs, and culturally, that was not something they were comfortable with. But the interconnection, and my son is in the Navy and spent 3 years in Japan, and so I had an opportunity to kind of get to see Japan through his eyes. The interdependence now of that ally and the interconnectedness with the United States at every level is starting to prompt, and sometimes for business reasons, they want to show their American counterparts. So they want to show, and they have a nice buildup, a large buildup in defenses now, that we do not want to see corruption. We do not want to have that as part of if we're building an aircraft carrier, we don't want it to be 40%, fluff. And so that is, sometimes people get to the right place for different reasons. And so sometimes those things get added. You know, there's an interesting, we didn't get time to, but there's an interesting provision. American companies that are publicly traded, as part of their compliance programs, have to educate, and this was a controversial area. I know Jerry would know that. They passed legislation that required these companies, for a whole variety of reasons, to educate their own employees on what it would be like, or what whistleblowing. They have to put it up in the cafeteria. All right. When I discussed that with my European counterparts, they were saying, "What are you, crazy? You're going to tell people how to be a whistleblower?" And I'm not saying that it has increased or decreased, but they are required to explain to not only the whistleblowing statutes. You know, we have a very strong anti-kickback statute that exists in the United States in the healthcare area. And so that is something that is completely foreign to my foreign counterparts. And so that's where we are. Anyway, I wanted to just give you the 30,000 foot